We'd like to acknowledge the traditional custodians of the land from which we broadcast today and acknowledge their elders, past, present, and emerging. Hi, everybody. This is Paula. This show is not about legal advice. It's really just about our experiences going through the process in the family law courts, what can work, what doesn't work, what's for you to consider to try. And it's just about the process, giving you some familiarity with it, and hope that gives you a little bit of a help.
You're listening to a Mel and Kim Productions podcast. What happens when a lawyer and a family mediator step into a bar? Join us to find out. Diane and Paula have real conversations about the family law process in Australia. Whether you're a part of the family law system or about to engage in the process, find out what the realities versus perceptions are. Diane and Paula don't hold back on their individual perspectives and experiences.
Welcome everybody back to A Lawyer and a Mediator Walk into a Bar. My name is Diane Loveday and my colleague and friend is
Paula Appelhans.
Yes. Today we're wanting to have a chat about the differences. So I know our last podcast we talked about my process, so the family law mediation process. And today we thought we'd shed a little bit of light about the actual legal pathway, because one of the things I hear a lot as a mediator is, well, if they don't agree, well, just take them to court.
And I hear that a lot. People walk in and then for some reason there's this perception that the minute they walk in, something can be done right away.
Yes.
And a process is a process, and it wouldn't be a process if it didn't take a little bit of time.
Yes. And then the whole notion of going to court. I mean, there's some really interesting statistics around going to court, because I know, less than 11% of people actually end up in front of a judge at the final hearing.
And that's what we discuss a lot too when somebody walks into my bar, walks into my realm, what that process really looks like from the start and all the different pathways it can take. And I really try to instill in folks that it's not a great process. I mean, it's the best there is at the moment. It's going to be changed again. I think at this point, every 2 to 3 years, family law court renews itself in many ways or revises itself. So it's a very active court in my view, not very static in how it does things. It's always looking to get better.
Yeah.
So that's great. But at the same time, that means there's something always changing.
It's very much a trial and error, I think, as well.
I think that's the best. Funny, trial and error. But I think you're absolutely.
But one of the issues I see with it, as this person, acting out there on the edges, is that the vast majority of the decisions are made based on the people who do end up in front of a judge, which is such a small proportion of the people who actually initiate litigation.
Well, the people also have to understand you don't go before a judge, somebody who actually determines or makes a judgment for some time. You go before judicial registrars.
So give our listeners an idea of what time frame from walking into your office to actually having an opportunity, because people also have this idea that you get to have your say in court.
And eventually you do. And you put it on paper, you put it on the forms. So, but exactly. When you first come into my office, first thing I'll ask you is, have you gone to mediation? Because there is something called a pre-filing checklist.
Yes.
And it is absolute. I remember when we things changed again in 2021, I almost got caught in that by not doing not requiring the certificate, not requiring having somebody actually go through the federal dispute resolution process, not doing the letter saying we're going to take you. So there are at least 4 or 5 steps. Yep. And the primary step is, have you gone to Family Dispute Resolution Service? Because that is a requirement. I need to get a certificate. Now, let's also be very clear. If there is family violence, there are ways to document that. But I'm going to suggest for a large number of people, family violence going to mediation is not really an issue, shouldn't be an issue, because I'm going to throw it back at you, because when it goes to family dispute resolution, you have processes as well for family violence.
Oh, absolutely.
Yeah, so we're all very aware of these type of challenges.
And one of the things, again, that I think people don't realise is our role in the process is to determine whether mediation is appropriate.
Right.
In which case we then handball it back to you. But so we in our process is we interview both parties individually, and that we then ask some very personal questions about their relationship to try and determine, is family violence an issue?
Right.
Some people are quite forthcoming, but not always. And I have actually sat with people who weren't aware that they were in what we would class as an abusive relationship.
If they're 3 years old, what kind of voice would they have?
Oh, we can do 4.
Yeah, we can do-
We can do 4. And I have actually experienced with this. You give them to the right therapist with the right skill set, you'd be surprised.
No, I've had a couple of kids. I know. But they were never shy in what they said either. So, I mean, my girls were always to the point.
Yeah.
My youngest daughter would always come to me. And from the time she was 3, she would come to me, here's the deal. So there are plenty of children like that. They tell you exactly what it is, and they're not going to deviate either. But again, I think just in our heads as adults, as parents, because I know I did. It's like, they're my kids. Don't you tell me what to do with my kids.
That
Finger
is
wagging.
the hardest part.
Yeah.
And if they've been primary parent, to relinquish some of that control is really difficult for some people. Really, really difficult.
But then it becomes that discussion of, is it control or is it really in the best interest?
Absolutely.
Same coin, different side, right? Different ridges.
Again, I think it's a whole podcast topic of talking about relinquishing that control, and how it can look, and the purpose of
why you do that, or what you're looking at when you do that.
Yeah, exactly.
And you're right, that is. So, but these are the things we try to look ahead on a little bit. Again, I like to look at the context of the situation as well, because if there is something like family violence, and family violence could be coercive control, it could be financial control now, emotional, physiological, physical, as well as psychological. I mean, there's so many avenues to it now. And it comes out in increments, unfortunately. So what somebody comes in with and what actually comes out through the process can be 10 different things.
Yeah.
So we do need to be aware of those things. So best case scenario, from the time they hand me that certificate, I get the letter out within a couple of days. We've assessed what we can as far as property. Again, high level of the children. Maybe they've already decided who's going to have what and who's going to be involved and how it's going to be involved. And we put that on paper.
Yeah.
Try to get that potential consent order from the get-go. That's how we. Now, we are required to give them a letter. We're required to give them, basically our side of the story, why we think this would be the best interest, why we think this would be the best part of the property settlement. You have to kind of give your side of the story to begin with as part of your intention to file. And then you have to say the words, we intend to file. So
what does that actually mean? Because I don't know that people really understand what that means when you have an intention to file.
So when you have an intention to file is that there are a flurry of, I believe, 8 to 11 forms that have to be filled out for the court. So, you start off with your initiating an application. But as part of that, there's usually an affidavit involved. Sometimes there's a parenting questionnaire that needs to be completed. An affidavit is your side of the story.
Right.
In legalese to some extent, but it puts out your position for the court to understand your position going in. It's usually an entry-level position, because as the process goes through, we'll find out different things, and it might need to change a little bit.
Right.
Or a lot. But so you have your initiating application, you put together an affidavit, which is your side of the story and why you think you should get whatever it is you think you should get out of this, whether it's property or time spent with the children or that you get sole responsibility. There's all these things you put into your affidavit. But then you have to fill out a financial statement. Then there's a financial questionnaire. Then there's a parenting questionnaire. And then there's the certificate that says you did everything you were supposed to do as far as family dispute resolution paperwork, and then you... So there's quite a few forms depending on your situation that need to be filled out in order to actually even file.
Right.
Filing fee, that changes every July 1st, so you have to pay the filing fees as well as the time for the lawyer to put it together. And then you can actually go through the process of filing it in the court portal. And once that's done, you can ask for, or they'll show up a calendar date now of when's the first date of return. Now, it can't be anything before, I believe it's 28 days from the time you actually serve the other side. So you actually have to pay somebody to take all these documents, a couple of the brochures that the court requires, and physically hand them to somebody. And then they have 28 days to respond. So, I mean,
if they can't get hold of the other person.
Well, you can have up to, I'm not going to say how long, but you can have some time to file.
Right.
To serve on the person. But it's a form of natural justice. The other side has to know you filed with the court, give them time to respond. Some people don't respond. And at that point, we're still into, a month away? And then at that point, once they're served, then the clock starts on when you can actually go back to what they call a first return.
What does that mean?
That means you go before a registrar and you talk about procedure. It's not about the story. It's not about who said why. At that point, it's just what do we need to go further? And the registrars are very tight now and tell you at the beginning of the process of the hearing, this tick, 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 tick. This is what I'm doing. This is what I will not do. Tick, tick, tick. I had one, she was so precise. It was fantastic, but it was very disconcerting to the client. It's like, you mean they're not going to listen to me today? No. They're not going to listen to you for a while. No. The best we can do is get stood down and try to get consent orders on how to move forward. And that means, is there going to be a family report? Is there going to be a child impact report? Is there going to be, are we requesting an independent children's lawyer? So it just...
Do you have to, is there always an independent children's lawyer appointed?
No.
Right. What's the criteria?
Not even when there should be one.
Right. Because I know in the changes to the legislation, the independent children, and this might be the reason why they don't get appointed, they actually have to meet the children now. Well, that must terrify a lot of lawyers.
I really think one of the conferences I went to, an online one, that was one of the discussions. Independent children's lawyers are assigned to the cases by the federal court. And at that point, they may not be able to factor in a visit with the child. One of the cases I had, they never met the children.
Yeah.
And they looked at me
used to happen a lot. Yeah.
Well, they looked at me like I was from, Wizard of Oz because I asked, have you met the children? Because the children at this point were like 9 and 13. Right. So we're not talking babies. We're talking a preteen who was very vocal. Have you seen a preteen female that was not vocal?
No.
But it was so if you're trying to manage the best interests of the child, how could you do that without even talking to the children?
Yeah.
I can understand when they're babies. I can understand, to a certain extent, but at the same time. But that's almost a very different factoring in of these people trying to meet the children now. Yeah. Because now that kind of twofold brings the child into the court process. Whereas before we were trying not to.
Yeah.
And now they've got to meet with a stranger and tell the story to a stranger, and that's another type of infliction, if you ask me.
Oh yeah.
It's one of those things where you see the good out of it, and then you're like, oh, but if you don't manage it right, then all of a sudden the child is square in the process where you were hoping you try to shield them. The whole thing is you're not supposed to discuss any of the aspects of the court case around the child. You're not supposed to have any discussions that talk about, well, the court says this now, you have to do this. The court orders us to do. Yeah. You're not supposed to have those conversations with the children. Not. But when you introduce an independent children's lawyer, that's a whole another can of...
Well, especially if there's someone who doesn't quite get the fact that a child is a child, not an adult, and you can't have adult conversations with them.
No.
Or you shouldn't have adult conversations. You can have. It doesn't necessarily do any good for the child. But
well, then they feel like, okay, if I say something wrong, Mommy and Daddy are going to have a problem, and I don't want to be the cause of the problem. And that was the whole idea of shielding them.
Yes.
And now we're like, okay, now the children's lawyer needs... But, I have I've been fortunate. I have worked with some really lovely, really strong advocates for children as an independent children's lawyer. Yeah. I would not have been able to get parenting orders without one in one matter that had been running for 3 years.
Wow.
Yeah.
But if that hasn't scared everybody off.
Exactly. Well, and again, so a lot of the changes were designed now to be 12 months. Everything should be done. Nobody's going to be lingering. Nobody's, are there still processes afoot that both parties could take to extend things if they wanted to. And again, the entire idea is that natural justice should also be afforded to the parties, and it should. I don't know. Yeah, you give me that look. I am a big believer in, we call it due process in the States. Here it's natural justice. I mean, the idea is that it's got to be fair.
Yeah.
It's got to be about as upfront and fair as you can be. So take the minute to let it be fair. If it means it takes another 30 days to do this, then okay. When it sucks, it sucks.
And I suppose then we have the conversation is what makes it suck?
Well, because you can't do anything in between the times. I mean, everything's kind of static.
So my understanding that when lawyers are sending letters to each other, which can take a great deal of time, there's something like a 2 or 3 week grace period between lawyers have about being able to send letters between each other. So it can take a month or more just for one letter exchange to happen.
Well, I hope not. I have had other sides that I've gotten to the point where I call them love letters because I'll get 3 a week. Yeah, because they can charge for them.
Wow, that's the entirely other side of. I call that one being litigated into submission.
Yeah.
Yeah.
Okay. Yeah, I call them love letters.
Yeah.
Because I get to the point where it's like, if this is how they're going to start it, I will respond once, very quickly, very shortly. I'm not going to spend my time and your time to pay me for every little letter back and forth. I will take out what's important out of them, and we'll have one response back, maybe once every 2 weeks. But it's got to be something that's very important to the matter. It's got to be something that is crucial to what's happening. If a child is not going to the doctor and we have to write about it back and forth, I'm going to pick up a phone. I get that everybody's like, it should be in writing and to a certain extent, but pick up a phone, do a file note. I've called. The kid's got to go to the doctor. Get him to the specialist.
This is why we are friends, because all too often I've worked with people, over the last 15 years where it doesn't happen like that. The lawyer, there is a litigious lawyer involved somewhere.
Always.
And I had one poor woman, she was drowning in the cost of all these letters that were being sent to her lawyer, and I said, instruct your lawyer not to respond unless they run it past you first, or you get the letter and send it, you respond yourself. And they wouldn't respond to me.
Well, not if they're represented. But at the same time, that's one thing where, again, communication is one thing. Communication is critical and crucial between the lawyers. A lot of times you send the letter or you don't get anything in response back. They're just going to lay it out for another 2 weeks. They're strategically going to wait.
Yep.
We're seeking instructions is the best line ever. Okay, well, how long do you think seeking instructions is going to take? I've got mine in less than an hour. Where are you on yours? So yes, and take some time. Talk to the client. I let them know I'm getting love letters. Here's my suggestion on how we do it. And I had a lovely barrister about 3 years ago because it was very antagonistic. And I don't like being antagonistic. I don't respond well to it, but it's like, okay, I do need to do something here because it had been almost 6 months of love letters. 6 months. And I'm going nuts. I feel like I need to respond, but then again, a lot of what they're doing is irrelevant. So I sat with a barrister, and she was lovely, and it's like, answer one, answer maybe only the 3 or 4 things that are actually pertinent out of the 6 letters you've received, and that's just so that way you're responding. The client knows you've really reviewed. The other side knows you reviewed for the relevant aspects of their 3-page letters, because they're never one page.
No.
I used to tease people, a lawyer can't say hello in 3 pages. I don't know why we're taught to do that, but somehow there's all these things that, it ends up coming out. I mean, do you remember being in high school or, it's like, do a 5-page essay. And I'm like, oh, my God, 5 pages. Yeah, I can whip out 3 pages and I'm still just saying hello. No, so unfortunately, that's not the problem anymore. But, I mean, the whole point is that, we try to negotiate from the get-go, starting with that first letter. Mm-hmm. Most lawyers I know do want to negotiate, try to get through that process. You get to a point where it's like, it's not happening. Mm-hmm. It's not going to happen. They're obfuscating, they're denying, whatever it is. You go to file. Best you're going to do is get a first return date, which means you get back to the registrar. But again, it's a registrar. They're not a decision maker.
And what's happening on the first return date, it's just really procedure.
All procedure, just nothing else.
This is what I need you to do.
Yeah. This is what we're going to do to get to the next phase. Are we
Yes.
going to have an interim defended hearing next?
Which is?
Then we go before a senior judicial registrar who is a decision maker.
Right.
But what are the process? What are the reports we need? What are the psych reports? Family report? I mean, how fast can we get through these things?
That's the other thing is family report, depending on who you have do it.
We could do a whole nother episode.
But so briefly, a family report is all members of the family are interviewed.
Yep. All the children, the parents with the child, the parents without the child without the parents. And if you do it privately, you could get it done quickly. Going through the federal court to have someone appointed can take months. Can take months to get that appointment.
Yeah.
So most people I do suggest opt for the private pay. That's another $8,000 or $10,000 dropped just for that family report. You spend a day, 2 hours for mom, 2 hours for dad, 2 hours for the child. Maybe an hour with the dad and child, maybe another hour with the mom and child. So it's an all-day process. So I'm not discounting the fact that this is money that they are earning, but in fact it's still a cost.
Yeah.
And it's a big cost.
I know of one report writer that charges $25,000. So,
I'm not paying her, but oh my God.
I know.
But still, these are these things that, that can happen and do. But once you get through that process, then it's like, okay, we've got all the reports now. We're going to an interim defended hearing. That's before another senior judicial registrar, somebody who's a decision maker. That's what you want to get to.
Yeah.
And after that, if you're lucky, you'll get some decisions in your favor, some decisions not in your favor, and then you go on again. Now, at that point, it's just an interim because the court wants to see how these decisions are working.
right.
So now if you're lucky, that's 6 months down the line, if you're lucky. Again, the court wants to do this within a year.
Yeah.
However, things happen, can't get the report writer, can't get the scheduling, can't get the report done in time, there's all these things that will add days, not just days, they'll add weeks and months to the process.
With so somewhere in there, they would also be, in some cases, requesting the FDR mediation within the court system.
Well, as part of the procedure, or as part of the procedure going back, the registrar can say, look, you need to go to federal dispute resolution. So we will bring in somebody who has been a registrar in the federal court. So they know the law, not just the law, but they know the evidence rules, they know what's in, what's out, and they've been very precise in their mediation. So, and again, I think sometimes it's just because it's the court ordering it, that whoever's being the most belligerent about doing this has a come-to meeting and and says, okay, they've been instructed, this is where it's at. You need to be upfront.
This is what's going to happen.
Yeah, this is what's going to happen. So yeah, that also happens. So there's several pathways, but any way you look at it, you don't talk to a decision maker for the first 3 to 6 months.
If everything runs smoothly.
If everything runs smoothly.
And everybody's on the same page and corresponding openly and quickly.
Yeah. So nothing is immediate about it. The more you can consent to, the more you can put into a consent order at any stage. I tell people to do it.
Yeah.
And again, the consent order is different than going back and having a final parenting order, because that'll be harder to change. But you have all this time to see what's working, what's not working. But the more you can agree before we get started, if we can limit it to just 1 or 2, maybe even 3 issues at the most, we narrow it down. My job is to narrow it down.
Oh, right.
Yeah.
So whereas my job is to expand it out.
Well,
So I'm
But the idea is that when you expand it, it finalizes it.
yes. So we're talking about all the possible issues that could be raised while you're trying to parent these kids. So we expand it out to try and cover off all contingencies.
Well, you have a wide net, and you want the wide net in the beginning, so then you can try to collect everything in. Everybody's in agreement. Everybody's aware of what they're agreeing to, aware of what are all the issues. You help them define those out as well. So that's why really when it comes to, I like the idea of the pre-filing checklist because it makes the parties do some homework, maybe get some insight into what's going to be happening. But a lot of times it comes down to they've made more decisions than not. And when they come to me and I can say, okay, well, then you've agreed to this. You've agreed to this. You've agreed to this. Then, okay, tick, tick, tick. Okay, we're down to this. What can we do to get movement on this? All right, let's go see what we can negotiate. And I'm not going to lie on that one. I'm sure there are other litigators that say, no, I don't want to go to court. But I tell all my clients, the more we stay out of court, the better.
Yeah.
The better. But if we go to court, there we go. Heels and hoops are off. You know, we're ready to fight. That's what we got to do. But
all of this is, and these are the sort of things that pop into mind. All of this is happening when you've only heard one half of the story.
yeah,
So, you go into this process blind. You really are not 100% sure of what you're going to get back from the other side.
never.
Yeah.
Let me put that in. Never.
Never. Okay. I'm thinking, some people might be honest, but
But I mean, people, it's one of those things we learn as adults to self-edit. We want to look good.
yeah.
We want to look good to somebody else. I think we've just learned to self-edit to how things, it's not like we're pathological sociopaths or anything and we don't realize there's a world around us, but we want to come off in the best light possible. That's natural.
I generally explain to clients that we have, perspective on this side of the table, a perspective on this side, and that they're yours. That's your belief systems. I get that. But I understand as the mediator is the truth sits somewhere in the middle.
Yeah.
Yeah. But I have the advantage
Of being able to look at both.
hearing both stories and trying to find some common ground and helping people work forward, which I don't envy you.
Well, I'm hoping when you do your job, mine will be less.
Yeah.
That's the hope anyway. That's the intent, I think.
Well, that's the purpose of a parenting plan. So these things work. This is what we've agreed to. Take this to your lawyers now.
Yep.
And go and work on the bits that don't work.
Yeah, exactly. And I'm not going to reinvent the wheel if they've already come to somebody like you and this is where they're at. Again, we don't want this going 6 months before somebody hears anything.
Yeah.
And that's the part of the process people really seem to. I want to tell my story, and I want you to tell your story, but it's going to be a while before we get there.
Yeah.
And sometimes the court's going to look at some of the things we think are pertinent and go, nah, we don't agree. Sometimes they just don't agree. So.
I had a client once explain who'd gone through the court system, and he said it felt to him like he was sitting on the back of a bus and somebody else was driving his life.
They are. I'm not even the bus driver. I'm not even the bus driver in this scenario.
No, it was somebody entirely different. So he was. I thought that was a very creative way of explaining how
it's
you
absolutely
lose
visual.
complete control
absolutely
of
visual.
what's going on when you go down the litigation path. And it takes, so to be clear, it can take at least 6 months before you get to a point where you might have a conversation with somebody who could make a decision, but it's not a judge at that point.
And no, it's not a final trial.
No.
I mean, if you're lucky, again, a couple of cases, 2 to 3 years before you get to a trial phase. So and the trial is 10 times worse than you ever thought it would ever be.
Yeah.
So I'm going to throw that out there. It's never what you think it's going to be.
And
You'll never be able to prepare enough for it. I'm sorry, but you never can. Your lawyers will, your barristers will, but you as an individual, it's not something you can ever prepare for. Or realize that, one of the things I do tell folks is you have to realize that after all of this is done, you still have to be parents.
Yes.
So whatever we do now, end run, you're still going to have to be the parents.
You're still going to have to communicate with each other. You're still going to have to make decisions together. You're still going to have to do birthdays and
holidays and figure all that out. But once we get it sorted, just run the program.
Yeah.
Everybody works forward. So I think I think that's about all we can say about the pre-filing.
You mentioned barristers a few times, and I'm not sure people completely understand why they need a barrister or why barristers need to become part of the process.
Well, that's again probably a whole other podcast on
fair
that.
enough.
But barristers are very critical to the actual defendant hearing and trial process.
Okay.
Some folks use them for everything they do every time they go to court. Some folks only use them as heavy hitters, but they really are the folks that take things to a trial.
Okay.
Or to that type of forum is where you would bring in a barrister.
So they're the performers.
In some ways, yeah, but wow, you get some performance out of it. But they're smart cookies. They know the law. They know the process, the procedures, the evidence. Which we do as well. But I mean, as far as the presentation, and
which is what I meant by the performance, because it's the presentation. Because I will talk to people about a property settlement, and one of the mitigating factors is whose barrister tells a better story.
Yes. or whose barrister finds the better evidence.
All right. So you come from that.
Yeah. I've had one who found the evidence we were looking for. I mean, we were digging deep.
So worth every penny then.
Oh, my God. I adore him. You get a good one, you adore him.
Yeah. Okay. So those are the ones you work
yeah.
with. All right.
All right. Well, thank you, everybody.
Yes. Thank you so much for listening.